Welcome. This is the Domain Name Law Show. We're here every Tuesday like clockwork. It's usually noon Pacific, 3 p.m. Eastern. Today, we're doing it at 2 Pacific, 5 p.m. Eastern because we've had a busy morning. Me and Jeff Neuman, one of your co-hosts, were busy. I'll tell you a little bit about that. There's 3 hosts of the show. My name's Todd Ryan. Also, David Michaels. So David and I will be taking care of the show today. I'm going to start by saying hello to my co-host, David. Hey, David, what's going on?
Hey, Todd. We're just enduring a heat wave here, and we'll get some relief tonight, maybe.
I did not know that. I didn't know it was, there's some thunderstorms back in the Midwest, but then, so it's hot in New York today, too, I guess? Hot in New York since it's hot where you're at, right, Dave? It should be hot in New York
Yeah,
City.
the whole eastern half of the U.S. and Canada have been like really hot for the last couple of days.
Yeah, I was hoping, I know Gerald Levine and Zach and Nat and a couple others, must be another couple lawyers I was thinking of that are having lunch today. It must be over with. I need to find out how it went because Jerry was like, Todd, I hope to see. I wish I could have been there and give Jerry a big old hug. Anyway, yeah, because I guess later this week they have the ICA New York City meetup, and I guess it begins tomorrow, and then today, everybody getting into town, so they're doing some stuff. But of course, I was saying we couldn't go, or I couldn't go. I know Jeff couldn't make it either. We were in depositions all day. Jeff mentioned it before about this case. We have some clients that we're representing who are plaintiffs in a case against GoDaddy. I'm not going to mention much of it here because we're right in the mix of it. Got another deposition on Friday and a couple next week. Been doing, basically both sides, of course, get deposed. But so speaking with a lot of different GoDaddy employees about their processes and certain instances, basically things that happen specifically with regards to our clients. But basically, we mentioned it before. We're going to talk about it in a couple weeks when Jeff's back and we're done with some of these depositions, but we're still in the midst of everything. But it's that case where a couple different clients of ours won some domains at auction, and then their names were clawed back after they had been building businesses on them. So it's not something new, and a lot of people have had clawbacks from GoDaddy. It just some people don't have the resources to try to make things right. That's what we're trying to do here. But yeah, so it's a long day. Really long day. Thanks for being here. Maybe, I think next week, David, I got a similar situation, so maybe we'll try this next Tuesday as well. I don't want to do it too late for you, but no, thanks, David, for being able to adjust the time. So anyway, this is maybe just a 1 or 2 week thing. Move the Domain Name Law Show back as opposed to just not doing it. Or David was going to do it. You can always handle it, but I do want to make sure that we have proper recordings so we can put our recordings on Shopify and Apple, and of course it's being streamed on YouTube right now. But David, have you noticed that have you searched and seen how easy it's for people to find us on Apple Podcasts and on Shopify? Spotify.
I haven't even bothered looking. I had no idea.
Yeah, what's cool, it's Spotify, not Shopify. I got Shopify. But no, it's pretty neat. People like to listen to it on certain platforms, but no, there's not a lot of domain name law shows, out there or content. So it's pretty easy for us to get indexed and, so people search domain name law and they'll find us pretty easy on these different platforms. But okay, thanks for being here. Yeah, for those in New York, next week I'd like to hear how this ICA meetup is going. Sounds like it's going to be a first-class event. If you want to take a look at our outline today, you can see what we're going to cover. dnlshow.com/outline. The very first thing I was going to touch on, David, was a client reached out. I spoke with them. They're in Europe, really. The gentleman was out of Cyprus, really, but he was a Greek resident. But anyway, it's basically this case: owner of .bet domain files an ACPA case to reverse a UDRP decision. But so a gentleman reached out to us over at JJN Solutions and said, "Hey, I lost this domain name merit.bet in a UDRP decision." And he said they lumped me in with two other respondents, some other domain owners, and I don't even know who those people are. But he didn't respond to the UDRP in a formal way. He did respond informally and say, "Hey, I'm not connected to these other companies, so I don't think I should be part of this UDRP." They didn't believe him because they thought there's a few reasons why Jeff and I noticed in the ACPA case he didn't say anything about his trademark that he had, and it was one of the reasons why we weren't thrilled about taking the case, because felt like his trademark wasn't strong and it was similar to the complainants. But anyway, so this was I bring it up because I just thought hit close to home. I think Andrew Alleman talked about it on his website, and then he posted this court listener link, which I saw anyway, so I just posted directly the court listener link. But yeah, I don't know. Do you have any? Did you take a look at this? Any comments or anything you noticed about this ACPA case? David, did this guy trying to get his name back?
There's something wrong on the signature block, but other than that, I don't see anything else wrong with it.
Yeah, you wouldn't know if you didn't know the background. There's, like I said, it's unusual that the person didn't how a generic ACPA filing. That's really what this is good for, to show, all right, this person lost a domain name in a UDRP, felt like he shouldn't have lost it because it shouldn't have been brought against him in the first place because he wasn't connected to these other respondents, and then just said, hey, we feel we have rights to this domain name. Anyway, I don't think it's a strong complaint, or I'm going to say it's not weak either, but it's pretty bland and pretty generic. So it's like if you lost a UDRP and you wanted to file a cookie cutter ACPA case, there's an example of something that nearly anybody could file. I say that because he didn't show that I have a trademark, and our trademark should suffice, or should be a pretty good argument to why we should be able to maintain or reverse the transfer of this domain name. All right, I could just go on and on.
Yeah, there's a lot of trademark owners out there for the word merits, like all around the
Yep.
world. There are, I don't know, looks like thousands of trademark owners for the word merits. So it's a very weak mark, very specific for a given company.
Yeah. Well, if you put it with bet, there's a really large hospitality company over in that area of the world that has a casino, has hotels under Marriott Hotels and Marriott Casino, very popular, very well known. Felt that this gentleman probably knew about this company, and bottom line is, we'll see what happens. He should have really just answered the UDRP formally and made his case that he shouldn't have been connected with these other respondents. Had a chance it wouldn't have been transferred. There wouldn't have been that decision, and then he wouldn't have had to, go on this route and spent money on an ACPA case. But we'll see how it goes. If you want to go to dnw.com, I know Andrew Alleman wrote about it, but I didn't even read that article. I don't think. I've been busy. The other cool article we'll get right to, a case, Brokerless.ai. And David, this one, just when I read the article in Domain Gang, and you can see our Brokerless.ai.
Well, I didn't like the decision because, the complaint says that they've been using the name since 2006, but their trademark application says since as early as May 2014. And they provide real estate listings and real estate information via the internet. So to me, it seems like it's clearly descriptive, or in the US, they call that merely descriptive, and therefore not registrable. if not even generic. But these people were able to convince the examiner to say, okay, put us on this. Here's a 2F claim, and we have been using this mark for a long time, so give us a registration. But in 2022, when the applicant filed their application, there were two other applications pending by another Florida company using iBrokerless and eBrokerless. The problem with those applications, well, they got canned earlier last year for one reason, and that is because they used one of those non-licensed um, organizations that help you apply for the trademark, but they actually impersonated the applicant or use some other attorney's fake credentials to log into the system at the USPTO and file the application. So if those guys had not screwed up, this complainant would not have had a registered trademark. And that would have been a problem for this complainant because they had no chance of winning this complaint. This domain was registered in 2023, it was put up for sale on Afternic. It had an Afternic get price lander with, asking for the name and contact information. So yeah, I would say there's no targeting because there's three applications pending in 2023 when the domain was registered. And what does .ai have to do with real estate listings? It's a different industry. So I think if this guy responded, he could have won, but he didn't even respond. So what can I say?
Yeah, when you don't respond, okay, we know that's what happens. So I think every company now thinks, oh, how do we incorporate AI and into this business, into our business, and now panelists and other people, it's like us lay people, we just sit on that. Okay, how would you incorporate AI into brokerless real estate listings? Well, I don't know. I'm sure if I sit back and thought about it, I can think, okay, so now they are, are using AI for these listings. But the long story short is there's a company that has these brokerless real estate listings. They were on brokerless.mls.com. They see somebody registered brokerless.ai. They probably, just like everybody else said, hey, .ai, I'm starting to see companies use that. I wish we had our .ai. And some people are so confused they think they need it to show that they are using AI or something. But it's becoming that popular of an extension where now we're seeing more and more complaints, UDRPs filed to try to, take these names. But so this guy didn't answer back, the domain owner, and the panelist, Evan Brown, just felt like, so to think, to not, and of course in real estate, but the brokerless is just it is a dictionary word. And, it was basically the $100,000 price. It just felt like, hey, you search brokerless. This panelist said you search brokerless on Google, you find this company, you charge $100,000 as that's the price you want. You're not putting it to use, so I'm just assuming you must have known about them. You're trying to get a lot more money than your cost. So that already is not direct targeting, but targeting enough. He felt like that is targeting. You're asking $100,000 for a name you spent a couple hundred. You must have known of that. You did any type of search at all. So this panelist, Evan Brown, just doesn't feel like domain investing is, obviously legitimate enough. And he felt like, that name is not generic enough. If you would have thought those two things, this is generic name, domain investing, they can price it at $1 million if they wanted. But anyway, this is a transfer. So they transferred the name brokerless.ai right to this real estate company, simple, easy peasy,
Yeah.
$1,500. Go ahead.
Oh, I was just looking at the .db database, and Brokerless is registered in 25 TLDs. 15 of them are active. Most of them are CCTLDs. But there's also like brokerlessagent.com, brokerlessboat.com, um, brokerlessfreight.com. So there are other companies out there using the term brokerless for unrelated things besides real estate, and maybe even real estate in other countries.
Yeah, they didn't like that they was asking 100,000. So you're a domain investor. You get panelists, I want to say effing panelists, who they want to sit back and they look at your price and they think, you know what, that's just too much. Like they think they know the price of names. And that's just too much more than your cost. You're wanting to get more than just reimbursed. It's unbelievable, that either is selling domains, is that legitimate or not? And as soon as they, come to, I don't know, some kind of conclusion or consensus that so selling domains is okay, it is legitimate business, then you have a right to price them what you want. So if somebody says, I have a store, I got them all priced at $100. I have a store, I have them all priced at $1,000,000. Both should be legitimate. And then, of course, they can look and say, hey, but that particular name that you own, Gucci.ai, you bought it after, Gucci had their mark. They are such a well-known, popular mark that you didn't do anything with it. We do believe that you knew about them. So with these super trademarks, I can see them saying, listen, you don't have a right just to own Coca-Cola and try to sell it. You're than just trying to sell it. Anyway, Brokerless.ai. The domain owner just didn't answer, just had a big expensive landing page, lost it. To get to our first case today, it's one that we are proud of over JJN. This guy reached out to us. Really smart developer on the East Coast. His name's Tony. But anyway, he was the respondent in this case, our first case, chainbridgeestates.com. And what Tony was, he's a developer, had this idea for this project where individuals, instead of have condos and basically let sort of a senior community have their own homes, and but still have access to medical services in the community, but yet not overbearing, not like a retirement community where everybody, lives in little apartments and, there's and half the people have 24-hour medical. It could be a wide range, but anyway, it was an all-inclusive community. It was like Sandals, but not for vacation. Anyway, he had this project. He decided was really developing it out, and then decided he wanted a partner in it because it was going to cost a lot. He had bought some land and was developing them out, but then he wanted a partner. Got a partner. This was several years ago, 5 years ago. He became, the partners put up a lot of the money, wealthy company on the East Coast there in Virginia, put up most of the money for the project. Tony became the manager of the project, and the project went forward. They named themselves Chainbridge Estates. He had thought of the name beforehand and was planning on using it solo, but then he got this partner, and then they actually hired a naming company and said, do we really want to name it Chainbridge Estates because it's on this road, Chainbridge, but do we want to name it anything else? So they hired a naming company and went through a few other names, but then they decided, you know what, a lot of people in the community already knew we were going to do something called Chainbridge's project, and this gentleman who was their manager, now he's no longer their manager, and then they have some other issues because he owned they were both owners, partners, members in this project, and then they have this dispute, and they're saying now we want the domain name. The name's they're already using the name, and what I mean, Tony already had the domain in his GoDaddy account, but he allowed them to be, he gave them access to the hosting so they could do all the website stuff and so on like that. He did some content, but anyway, so he gave them access so they could, manage the website, and they just weren't happy, wanted the name because they knew they was in his name, and then they felt like, oh no, we're going to have to license it from him, and we just feel like we have rights to it. The project's known by Chainbridge Estates. He's not, and so on. They filed a UDRP. We laid it out pretty good, to say, obviously, this is a business dispute. He does have rights to the name. He, registered the name fair and square, definitely not in bad faith. And Well, the panel was a 3-member panel. Said, yeah, not only this isn't a UDRP, certainly not a case of cyber squatting, but if you do have a business dispute, take it somewhere else. But you should have known you weren't going to win this case, especially you're leaving some things out of your complaint anyway about your relationship with the person anyway. So the 3-member panel felt like this was just definitely an abuse of the system. So they ruled complaint denied
So
and RDNH. So we got as much as we could out of it. David, when you saw Chain Bridge
how did you tell
Estates,
me?
yeah, go ahead.
Yeah, can you tell me how you guys argued around the part where in the supplemental filing they said that respondent had agreed to transfer the domain to the complainant, but now has chosen to challenge the valid foreclosure of his business entity and retain control of the domain name. So what was going on there? Were they trying to shut down the whole business after
He was willing
2025?
to transfer the names if they came to an agreement on, some sort of really a few